So negligence really just means that you could have stopped something bad from happening, but you didn't. Uh, but that's kind of hard to pin down exactly what that means. So let me give maybe a broader or a more maybe not broader, but a more full definition of negligence. First of all, we have to recognize that the law recognizes what a reasonable person's standard. What that means is that in order to have acted in such a way that you weren't negligent, you should have acted the way a normal, reasonable person would act. So, for example, if you were to see someone walking down the street with headphones on and they couldn't hear the train coming, you probably can't just stand there and watch them get hit by the train. A reasonable person would try to run to the person and let them know that they were walking toward a train. So the standard of care is what a reasonable person would do in a situation. So the elements of negligence are that we have a duty of care, a responsibility, and that we breach that duty, and then that our breach of that duty caused another person to be injured. So let me give an example of this. If I had my granddaughter and was taking care of her for the weekend, and I decided to go to the store and take her with me, most people would say, a reasonable person would say, I have a duty to care for and take care of my granddaughter. So when I put her in the car with me, I have a duty to buckle her into her child safety seat. There's also a law that says I have to do that. But when I get to the store and I put her in the shopping cart, I would have an obligation or a duty to make sure that she's safe in that cart. So as I go through the store, let's say I didn't buckle her in, and she's standing up in the cart and I'm not doing anything about it, and she falls out of the cart and injures herself. Not too seriously, but she gets a big knot on her head. Nothing that my daughter, well, I don't know, my daughter would be pretty mad if I didn't take care of my granddaughter. So now we can say I breached my duty because I didn't buckle her in and I didn't watch her as she was standing in the cart. And that my breach of duty was the cause of her injury. In this case, it would be what's called an actual cause. Approximate cause would be a cause that was foreseeable and not too remote. So for example, maybe I went to the car place and they put a tire on for me and they didn't tighten down the lug nuts very well. And as I'm driving down the road, my tire falls off my car and hits a pedestrian and hurts them. We would say that the proximate cause was not me driving down the road. That's not what injured the pedestrian, even though they wouldn't have been injured if I hadn't been driving down the road. But really, the proximate cause was that the tire company or the car company, the mechanics didn't tighten down the tire. And then finally, there were some damages. So back to my original example with my granddaughter, the cost of the doctor's bill would be my responsibility in a tort situation. Of course, most people, when they breach their duty and recognize they had a duty, they're usually pretty eager to make things right. So very often, things like this don't go to court because the people involved just do the right thing. But this is the standard for negligence that would be faced if we had to go to court in a tort situation.